All right, let's talk about the internet. We've basically got two different rule books running the show right now, Europe's GDPR and California's CCPA. We're going to break down what they are and why they matter so much for your personal data.
Every single time you click or browse or buy something online, you're leaving behind this digital footprint. So have you ever stopped to wonder who's actually protecting all that data? Well, the answer isn't so simple anymore. It really depends on where you live and where the companies you're dealing with are based.
Okay, so in one corner, you've got the GDPR. That's Europe's big one, the General Data Protection Regulation. Seriously, it's one of the toughest, most comprehensive privacy laws on the planet. And in the other corner, we have the CCPA, the California Consumer Privacy Act. And hey, don't let that California name fool you. We're talking about an economy that's, the fifth largest in the world? So when California makes a rule, it sends ripples across the globe, affecting pretty much everyone. So here's the most important part. These laws aren't just some boring legal stuff for corporations and their lawyers. Nope. They actually give you, the person browsing the web, some real power. So let's dig into what you can actually do with your data now. Think about it. If you could have one superpower to control your personal data, what would it be? It's a cool question, right? Well, both of these laws actually focus on one that's, it's pretty fundamental. It's basically the right to be forgotten. I mean, how cool is that? Now, the language is a little different depending on the rulebook. GDPR calls it the right to erasure, and CCPA calls it the right to deletion. But look, potato, the idea is exactly the same. You now have the right to go up to a company and say, hey, delete everything you have on me. It's pretty much a digital reset button for your life. Okay, but here's where things start to diverge a bit. It really gets to the heart of their different philosophies. With GDPR, you get this really broad right to object. That means you can object to your data being processed at all for certain things. The CCPA is a bit more specific. It gives you the right to opt out, which is laser-focused on stopping a business from selling your data. So think of it this way. One is about how your data is used, and the other is about how it's sold. All right, so we've talked about your new powers, but who do these rules actually apply to? Like, does that app you use every day have to play by these rules? And maybe the biggest question, are you even protected? This breakdown makes it super clear. The GDPR, it's huge. It's incredibly broad. It protects data subjects, which is just a fancy way of saying pretty much any living person whose data gets handled by a company that has to follow the rule. And it applies to everyone, public, private, even nonprofits. The CCPA, though, is way more targeted. It's for consumers, which means California residents. And it only hits for-profit businesses that are big enough, making over $25 million a year, for example. That means a ton of small businesses and startups, they're totally exempt. And that is a massive difference from GDPR's everybody-in approach. So all these differences in who's covered, they point to something much deeper, a real philosophical split. It really boils down to two totally different ways of looking at privacy. Is it about getting permission before you do anything, or is it about giving people protection after their data's been collected? The best way to think about this is to stick with our rulebook idea. It's like you're playing a game, but there are two completely different rulebooks. Both of them want the game to be fair, for sure. But man, the way they enforce the rules is night and day. Okay, so the GDPR rulebook, you open it to page 1, and bam, legal basis. What does that mean? It means a company can't even look at your data, let alone touch it, unless they have a really good pre-approved reason. Like they need your explicit consent, or they need the data to, say, ship you something you bought. It is a total permission-first system. All right, now let's grab the CCPA rulebook. You flip through it and, that whole legal basis chapter, it's just not there. The law doesn't make companies get a lawful reason before they collect your data. So where does the CCPA's power come from? It all kicks in after your data has already been collected. The whole philosophy is built around two things. Transparency, they have to tell you what they're grabbing, and your right to yell stop. Specifically, your right to opt out and prevent them from selling your info to somebody else. It's all about protection, not permission. Okay, let's get into the nitty-gritty for a second. When these laws say personal data or personal information, what are we actually talking about? Because I guarantee you the definition is way, way broader than you probably think. This right here, this is directly from the CCPA. And just listen to how expansive it is. The key thing to notice here is that it's not just about info linked to a person, but also to a household. Think about that. That means the data from your family's smart speaker, yep, that could totally be considered personal information under this law. So let's look at a few examples. I mean, of course it covers the obvious stuff, but it also includes your browsing history, your location data, even biometric info like a fingerprint. But, and this is the part that blows my mind, it includes inferences. So what does that mean? It means if a company takes your data and uses it to guess things about you, like what you like, how you behave, what you're good at, those guesses themselves are considered your personal information. That is a total game changer. So there you have it, two super powerful, totally distinct landmark laws. On one hand, you've got Europe's broad permission-first approach, and on the other, California's more targeted protection-first framework. But make no mistake, both of them are fundamentally changing how we interact with technology every day. And all of this leaves us with a really big question, right? We're all living in this one interconnected digital world, but we have these two completely different rule books trying to manage it. So what's the future going to look like? Will one of these philosophies win out, or are we going to see some kind of hybrid model emerge? I mean, what do you think is going to be the approach that defines online privacy for the next generation?